Joining us now, former Manhattan Assistant DA Catherine Christian, former federal prosecutor, Georgetown School of Law professor Paul Butler. They are both MSNBC legal analysts, and MSNBC legal correspondent Lisa Rubin. So, Lisa, what is the latest we know about a request, a timeline? What's happening here?
My understanding, Chris, is that the president has not only authorized but directed the Attorney General Pam Bondi to make a request to the federal district court here in Manhattan for the release of grand jury testimony. The reason he has directed her to do that, and she has accepted, by the way, that request, is because under the existing framework for grand jury materials in federal courts, the Attorney General can't do that on her own. They can only be released in certain circumstances, and statutorily, none of those circumstances are met by the present situation. That means they'll need a federal judge to sign off. And in the Second Circuit, that's a federal appeals court where we are now here in Manhattan, the rule basically says that even if you don't have one of the statutory exceptions to the rule that grand jury materials are supposed to be secret, a court in their inherent authority can determine that there are special circumstances that justify the release of grand jury materials. The question is whether the judge here will determine that there are such special circumstances. Certainly, Jeffrey Epstein is dead, which makes this different than your ordinary criminal case where there are grand jury materials. On the other hand, there are many, many, many very much alive victims, and they have a constitutional right and a statutory right to privacy that should preclude the release of any of these materials, regardless of what the judge's thoughts on the special circumstances are.
So, Catherine, I have so many questions. First of all, if you're somebody particularly in a delicate situation like that who's going to go before a grand jury, would you be told, would you tell them as the lawyer, this is going to be private, this is sealed because it is a grand jury process, number one. Number two, what we know to be what's pushed the president and thus Pam Bondi to do this, the public wants to know, would that be considered reason enough for a judge to make a decision to make transcripts public?
Well, I'll answer your first question. That's exactly what you tell witnesses before they testify in the grand jury. What I would tell my witnesses, my victims, is this is secret. It cannot be revealed. In fact, it is a crime for me or members of the grand jury to reveal this. I would tell them if there is a trial, obviously you're going to testify. It's going to be in public, and that will come out. But the testimony itself and the fact that you testified is secret. So it's not just the victims who, and these are sex crimes victims, and many of them were minors at the time. There are also, you're protecting people who have been accused of crimes, but have not been indicted, either because the government determined that there was no crime committed that could be proven beyond a reasonable doubt, or there wasn't even probable cause. So those people need to also be protected as part of the process. And in this case, I should also say grand jury testimony is just a smidgen of evidence that is in a prosecutor's case. In this case, you may recall when it was going to trial before Mr. Epstein died, the prosecutors revealed that there were almost 1 million pages of documents in this case. Now, we don't know how many of those documents were part of received as pursuant to a grand jury subpoena, which means that they are also secret. So, yes, is this a special and exceptional circumstance that MAGA and maybe some Democrats are upset and they want to see it? I don't think so, but a judge may disagree.
So tell us, Paul, how this would work. So if Pam Bondi goes and she makes this request, I presume the other side, maybe it's a lawyer for one or more of the witnesses, can oppose it. Can they ask for depositions? Could this open up a whole other can of worms? What happens? How does this process unfold?
So the judge has to weigh the secrecy and privacy interests of witnesses who appear before the grand jury against any public interest in revealing the information that the grand jury heard. Chris, as a federal prosecutor, I made hundreds of appearances before grand juries all over the United States. I've never had evidence released for a reason like this. Typically, the only way that grand jury evidence gets out is if the defendant goes to trial and she is entitled to a certain portion of that evidence. But in this case, we have to ask a legitimate question about the good faith of the Attorney General. As Catherine mentioned, Right now, she controls millions of pages of evidence, in this case, documents, that she could release without going to a judge. She could release it on her own accord. Think of the wiretap of Ghislaine Maxwell's phone. Think of the visitor's log to Jeffrey Epstein's private island. Think of FBI witness reports. What she's saying is that she's asking a court to release evidence that's outside of her control, while at the same time, she's refusing to release the vast trove of evidence that she controls right now.
Well, it also raises the question, again, based on what Catherine said and based on what we presume to be part of this information that would be released. We don't know the specifics, but we have an idea of what the grand jury was looking for, right? This is not going to answer the questions that MAGA World seems to have, or wouldn't seem to.
It might and it might not. But, Chris, there's one other consideration that I want to put on the table, and that has to do with Ghislaine Maxwell, who's in the process of still appealing her conviction. And her rights here matter, too, and they should matter to the Attorney General.
Before the Supreme Court, right, at
Correct.
this point?
She was convicted. She was sentenced to 20 years in prison. That sentence has been upheld by the Second Circuit, and now she is appealing to the Supreme Court. But in the event that her conviction, for example, is reversed and she gets a new trial, the public release of all of these materials could compromise her right to a fair trial. It could taint the jury pool. It could be severely prejudicial to her as a defendant. You would think that the Department of Justice also has an interest in preserving the integrity of its proceedings against her, to the extent that she is a person that they believe should have been held accountable for Jeffrey Epstein's sex trafficking ring.
And then you have the little additional piece of information, Lisa, which is that a key lawyer in the Maxwell case, Jim Comey's daughter, was fired.
Yes, and that is a mystery to me, and I'll tell you why. If somebody is looking to pin the blame for the failure to release the Epstein files on someone, Maureen Comey is not the right person. In fact, if you are interested in figuring out who the steadfast advocates for victims are here, and we should all be focused on victims of child sex abuse, Maureen Comey has done quite a bit to advance the cause of justice for people, adults and children alike, who are victims of child sex abuse. She was involved in the indictment of Jeffrey Epstein. She was involved in the indictment and prosecution of Ghislaine Maxwell. She had the last word in that case as the person who delivered the rebuttal. She was involved in the prosecution of Robert Haddon. He was the Columbia University gynecologist who was indicted for sexually abusing over 245 of his patients. That's not a person who isn't putting victims' interests first. Now, has Maureen Comey submitted affidavits in cases saying this party or that party shouldn't have access to Epstein-related files because of the privacy interests of victims, because of ongoing law enforcement investigations, including the Maxwell case and how it might turn out? Absolutely. But she's not the right person to blame here. And if that's the reason for her firing, and again, the letter given to her cites no reason other than Article 2 of the Constitution, that's a really misguided political distraction, not a warranted disciplinary action.
Paul, understanding that all of these cases can be different, also understanding what you said, that is, in hundreds of cases, you've never seen a judge decide in a situation like this to open up these records. How long might it take? Is this something a judge would decide quickly?
The judge might decide it relatively quickly, but almost certainly whatever side loses will appeal it. And so this could go on for a while. I think the safest legal guess, if you will, is that the public will never see most of the grand jury material because the Attorney General won't be able to meet the very high standard of privacy and secrecy. Again, the reason is for privacy in grand jury investigations is to protect the integrity of the investigation, to prevent witnesses from being intimidated, and also lots of people come before a grand jury who aren't charged. And the idea is that their reputations should be safeguarded.
So then we go to Catherine, President Trump threatening to sue the Wall Street Journal. So just to remind folks, there apparently was a book made for Jeffrey Epstein's 50th birthday. A lot of people wrote things, put together pages. The Wall Street Journal has seen a page that they say is attributed to Donald Trump. He has vehemently denied that he did it. Do you think that President Trump could have a case? Is it potentially a 60 Minutes type move where He could win a settlement without an admission of guilt on the part of the Wall Street Journal. We do know, for example, that he spoke to the Wall Street Journal and they decided to run the story anyway. But tell us about a possible lawsuit, which President Trump has done before.
And you said exactly. I think the president is hoping it's a 60 Minutes case or an ABC, George Stephanopoulos case. But in this case, the fact that he called the Wall Street Journal and they did it anyway says that they're not afraid to be intimidated. And truth is a defense. So if this letter exists or they have rock solid sources that have seen this, it's going to be a very hard case for the president to win at trial. He's probably not hoping for a trial. He's hoping for a settlement. But it's considered actual malice, reckless disregard for the truth. Can he prove that the Wall Street Journal has a reckless disregard for the truth? And if it's true, then there's clearly no reckless disregard for the truth. So if the letter exists, if the Wall Street Journal has seen this, if they have sourcing that proves it exists, then he can sue. And the Wall Street Journal, I'm not their lawyers, they should be steadfast.